started. Thank you all for coming to our slightly early Texas Independence Day event. For those who don't know, it's next Friday, March 2nd. But today we have a very exciting presentation. We have the newest Texas Supreme Court Justice, Justice Jimmy Blacklock, here to speak on federalism and states' rights. My name is Amanda Sauls, and I'm this year's president of the Texas Federalist Society. The Federalist Society is a national network comprised of conservative and libertarian attorneys, judges, scholars, and students. As a student chapter, the Texas Federalist Society strives to promote freedom, federalism, and the rule of law, and we do so through facilitating debate and discussion within the law school community. So today we have a chance to highlight one of those ideals, federalism, and I'm going to go ahead and hand it over to Ashley Trosses, our VP of Speaker, to introduce Justice Blacklock.
Thank you.
Justice Jimmy Blacklock is a sixth-generation Texan and was born in Houston and raised in Missouri City, Texas. He graduated from the University of Texas at Austin and Yale Law School, where he was a member of the Federalist Society. Justice Blacklock served as a law clerk for Judge Jerry Smith on the U.S. Court of Appeals for the Fifth Circuit and was appointed by President George W. Bush to a position in the Civil Rights Division of the U.S. Justice Department. After working in private law practice, Justice Blacklock began working for the Texas Attorney General's office. He was appointed by then Attorney General Greg Abbott to be a Deputy Attorney General, where he oversaw the Open Records Division and the drafting of Attorney General opinions. When Greg Abbott was elected governor, he immediately tapped Justice Blacklock to be his top lawyer at the governor's office, where he advised the governor and his staff on legal questions impacting the governor's legislative and policy agenda. He was appointed to the Texas Supreme Court by Governor Abbott just last month. So will you join me in welcoming Justice Blacklock?
Thank you for that introduction. It's a real pleasure to be here at UT. I went here for undergrad, not law school, but it's always good to be back on campus. And it's a particular pleasure to be here with the Federalist Society, just an extraordinary organization that exists to promote the rule of law, promote individual liberty, promote the separation of powers, not just between the branches of government at the federal level, but between the federal government and the states, and then of course to promote a vision of the role of the judiciary that is limited and proper under our Constitution. The Federalist Society, as those of you who are members around here probably have come to know, can be on campuses, on law school campuses, a minority voice, as sort of a voice in the wilderness, it may feel like at times, but the real world impact of this organization is just extraordinary. It's been so concrete and so long-lasting, and so much more so than so much of what else goes on at law schools, and I am evidence of that, or indirectly. One of the things that President Trump has done very, very successfully is appoint good judges to the federal courts, and the reason that he's been able to do that, I think, is primarily because of his wise decision to seek counsel from the Federalist Society, from the leadership of the Federalist Society in Washington, D.C., and from its network of conservative and libertarian lawyers all over the country. He's made those people one of the most prominent voices advising him on his decisions about federal judges, and his appointment of Justice Gorsuch is, in my mind, perhaps his signature accomplishment at this point. It's a wonderful appointment, and the Federalist Society was instrumental in that decision. The President's also made 3 excellent appointments to the Fifth Circuit, our federal court here in Texas. Andy Oldham, my former colleague at the Governor's Office and the Attorney General's Office, who some of you may know, wonderful man and a fantastic lawyer, who I hope will be very swiftly conferred by the Senate. He's just been announced by the President. Jim Ho, who hired me at the AG's office, gave me my start in government service, got me in the door with Greg Abbott, who was the Attorney General at the time. Jim Ho is on the Fifth Circuit now. And of course, Don Willett, who you probably also know, and who served the Texas Supreme Court with great distinction for many years. His ascent to the Fifth Circuit is the reason why there was a vacancy for me to be appointed to. And I'm so honored and privileged to have been appointed by the governor to that vacancy. But all of that is to say that indirectly I am also the beneficiary of the good work of the Federalist Society in helping the president appoint good judges. And there's stories like that all over the country where people in the conservative legal movement and the conservative political movement more generally have been promoted to important positions in this administration, and that has a trickle-down effect all throughout our community at different levels of government. So anyway, I'm just delighted to be here and delighted to be with the Federalist Society. I was a Longhorn from a young age, as I said, went to Yale Law School where I was in the Federalist Society. I came back to Texas, clerked for Judge Jerry Smith on the Fifth Circuit. If any of you have a chance to clerk, I want to put in a quick plug for clerking. It is an extraordinary opportunity to see what courts do from the inside. If you are at all considering it, it's the best job I've ever had, and I don't know very many clerks who, no matter where they clerked, view it differently. So I want to highlight that as a little one-year blip on my resume that has had an extraordinary impact on my legal career and on the way that I've been able to serve clients as a lawyer, because I've had that insight into the way that the courts work from that clerkship. So I went to work at Vincent & Elkins after that, was doing commercial litigation, and what I really wanted to be doing was constitutional law. I wanted to be litigating these big cases that affect the way that we are governed, cases that you read about in the newspaper, and there aren't a lot of jobs, particularly for young lawyers, that allow you to do that. And so I looked around, and President Obama had just been elected. This was around 2008. I'd been at V&E for a few years and knew that I wanted something different. And there was a guy at the Attorney General's office who was starting to make a name for himself suing the federal government. And that was Greg Abbott. And I thought, that's where I can go do this. That's where I can work on these cases. I can go do what I dreamed of doing at this place in state government. And as I said, Jim Ho had clerked for the same judge as me. He was the Solicitor General at the time. He clerked for Jerry Smith. And so that's another way that the clerkship, had a palpable benefit for me and got me to be a part of that community of people. But anyway, Jim brought me into the AG's office and gave me that first opportunity. I took a pay cut of maybe 70–80% to do that, and never ever once regretted that or looked back and missed the money or thought that I should have handled that differently. It was the best decision I've ever made in my career to go to work for the AG's office working on those cases. And as I said, President Obama had just been elected, and so what was happening in 2009 when I took this job was that the Affordable Care Act was being passed. And that brings us to the topic of federalism, which is the topic of the discussion here today. It's such an important topic. And one of the constitutional pillars of federalism, of course, is the 10th Amendment. Now, the 10th Amendment states that the powers not delegated to the federal government by the Constitution belong to the states and to the people, not to the federal government. And it's been called a tautology, and in a sense it is, because it just says that anything not delegated to the federal government isn't delegated to the federal government, right? But if the 10th Amendment didn't exist, I could certainly imagine lawyers arguing and judges perhaps agreeing that the many powers expressly delegated to Congress in Article 1, Section 8, and elsewhere in the Constitution are a non-exhaustive list of the federal government's powers. A broad, open, and the federal government actually has broad and open-ended authority, general police power throughout the country. And if there were no real limits on the power of the federal government, then of course federalism wouldn't exist at all. We wouldn't be talking about this if the federal government had that kind of power. Any power remaining in the states would be solely at the grace of the federal government and would in reality be no power at all. But the 10th Amendment does exist, and it makes very, very clear beyond any lawyerly argument that any judge could buy that the powers not expressly delegated to the federal government are reserved to the states and to the people. There is no broad residual pool of general authority vested in the federal government. There is no federal police power. The states did not give up that police power. The police power remains in the states, and they didn't give it up when they entered into the Constitution. Those are fundamental principles about the way we're governed that we don't think about too often. We don't hear on CNN or on the radio. People don't talk in those terms, but that is, at a very basic level, the way our government works, and the 10th Amendment really defines the relationship between the states and the federal government. And so one of the powers, going back to the Affordable Care Act, one of the powers that the federal government is delegated in the Constitution is the power to regulate commerce among the several states. And the extent of that power was the primary issue that we litigated in the Affordable Care Act case. One of the primary features of the Act, as you probably recall, it's been debated, of course, up until very recently, was the individual mandate, which required that every American purchase health insurance. And it was an unprecedented requirement in the sense that rather than just regulating commerce that already existed among the states and between people, it actually required people to enter into a commercial transaction, whether they had any interest in doing that or not. It required you to participate in commerce even if you didn't want to. And so rather than regulating commerce, as Congress can do, the individual mandate compelled commerce. And I, as a relatively young lawyer, had the immense privilege of sitting around the table with a great team of lawyers that Greg Abbott assembled, Jim, the Attorney General himself, several others of us, in those first days after Obamacare was passed, talking through all of this and trying to figure out how we can go to federal court and make the case that this exceeds Congress's authority. And we did that. And we went with a coalition of states, about 26 states, I think it was a majority of states. We filed in Florida, ended up going through the 11th Circuit, and all the way to the Supreme Court under this theory about what the Commerce Clause means and this distinction between regulation of commerce that exists in the world and compulsion of commerce that does not already exist. And what most people remember about that case is that we lost. There were 4 votes to enjoin the act in its entirety as completely beyond Congress's Commerce Clause authority. There were also 4 votes to uphold the act as completely within Congress's Commerce Clause authority. Justice Roberts, the last vote, sort of sidestepped the issue in a way that we didn't really anticipate and that the federal government didn't anticipate in their defense of the act. He decided that the individual mandate was actually authorized not by the Commerce Clause but by Congress's taxing authority. And so you had 4 votes to uphold the act under the Commerce Clause, you had 1 vote to uphold the act under the taxing power, which meant you had 5 votes to uphold the individual mandate. And so we lost the case. But what a lot of people don't remember is that Roberts joined the portion of the dissenting opinion that held that the individual mandate was not authorized by Congress's Commerce Clause authority. And so we actually had 5 votes. And there's a precedent on the books now, a Supreme Court precedent on the books that says that compulsion of commerce by Congress exceeded its power to regulate commerce among the several states. And Obamacare is what it is. It's a political football. Some of it has been repealed, some of it goes on, and that will probably be the case for many, many years. But I hope that into the future, the silent but very real precedential victory that we were able to achieve in that case will have an impact on future cases and will have an impact also on the way that Congress looks at its own authority. Another issue that I got to work on that implicates federalism when I was at the AG's office is redistricting. Perhaps no issue more contentious, more fraught with peril on so many levels, and more at the heart of this intersection of state and federal power that's so important to the way that we're governed. Article 1, Section 4 of the Constitution says that the time, places, and manner of holding elections for representatives, meaning in Congress, shall be prescribed in each state by the legislature thereof. So the Constitution very explicitly gives state legislatures, and only state legislatures, the authority over matters such as the creation and line drawing of the districts by which we elect members of Congress. And at the state legislative level, those lines for the state House and the state Senate, the state legislature also has the same authority to draw those districts. But after the legislature drew the lines in 2010, they drew the lines in the 2011 session after the 2010 census, which changed the demographics and required the lines to be redrawn. So in the 2011 session, they redraw the lines, and as usual, those lines were challenged in federal court under the Voting Rights Act, a federal statute that prohibits racial discrimination in voting practices. And if any of you have studied redistricting litigation or had any exposure to it, you know that these suits are commonplace. They take place almost every time lines are redrawn, almost anywhere in the country. People aren't happy with it and come up with legal theories for how to challenge the maps and try to get the courts to draw the maps in a way that's more suitable to what the plaintiff's political vision is. But this case is actually still going on. It started in 2010. We went to the Supreme Court once early on in this case, and that's what I want to talk about just a little bit. The case is actually back in the Supreme Court. We're in 2018, so the case is 7 years old. I think it was filed in the spring of 2011, and it's bounced back and forth, and we're about to make it to 2020 when there'll be a new census and new lines drawn. And it may be that this case lasts that entire time and is mooted by new lines drawn after the 2020 census. That's how complex is the word I'll use. That's how complex redistricting litigation can be. And because redistricting litigation is so ubiquitous, one of the things that we saw in 2011 when we were talking to legislators about the lines they were thinking about drawing is that even the legislators who are elected to do this and who are charged by the Constitution with responsibility for voting to create these lines, they assume often that the courts will actually have the last word on redistricting. And they'll sort of, they'll push off the lawyers to the side and say, yeah, well, the courts are going to figure that out, and we all know that the federal courts are going to draw these lines for us someday anyway, so maybe we're not going to put as much time into it or worry too much about the bits and pieces of it. And that attitude, I think, also existed in the federal judiciary. What happened early on in this case is that the plaintiffs sued, they challenged several districts. There are 150 state House districts, there are 32 state Senate districts, there are 36 congressional districts. So these lines are just all over the state of Texas. Squiggly lines everywhere. You've seen these maps. The plaintiffs challenged 10% perhaps of those districts under various theories, under the Voting Rights Act and the Constitution. And the district court agreed with the plaintiffs as to some of those challenges, agreed that the map violated the Voting Rights Act in certain ways, this district, that district. But the real problem with what the court did is that because of those violations, the court took it upon itself to redraw the entire map. The court said, this map is infected with Voting Rights Act violations. It's therefore rotten to its core and has to be thrown out. And all this work that the legislature did and all of the input that the people of Texas gave through their election of those representatives who then drew those lines, that's gone. And a 3-judge panel of federal judges drew the map the way it thought the map should be drawn. Just a just map based on what the court viewed to be legitimate redistricting principles that should be motivating legislatures when they do these things. And as I said, redistricting litigation is so contentious and so political. So often these cases go up on appeal, and they're 5-4 in the Supreme Court, or they're 6-3, and the justices will line up along predictable partisan lines. And it will feed the narrative that some people have in their heads that all the courts are doing is acting as proxies for the political impulses behind the judges. This was a case where that was emphatically not what was going on at the United States Supreme Court. We won that case 9-0. Even though the map that the judges had drawn in the federal court was much more favorable to the Democrats and was lauded by one side of the political spectrum who supports several of the justices on the Supreme Court. All 9 justices agreed with us that when there are problems with the map legally, when this district or that district here and there in the map may violate the Voting Rights Act, that the remedy is not to throw everything that the people's representatives have done into the trash. The remedy is to go in and surgically alter those pieces of the map that are infected with legal violations and leave, to the greatest extent possible, the rest of the map and all the choices that the legislators have made intact. And lots and lots of litigation has taken place since then about whether these Voting Rights Act violations actually exist, what's the appropriate remedy for them. As I said, it's still ongoing. It's now up in the Supreme Court on the question of what the Voting Rights Act means and to what extent the maps violate the Voting Rights Act. But amidst all of that rancor, it's encouraging for me to look back several years now, back to I think it was 2012, on that ability to achieve unanimity in the Supreme Court on such a divisive political issue, and unanimity on such an important principle that it is the people, through their elected representatives, that are responsible for these important decisions about how we're governed. It's not judges. It's not any one political party or another. It's not one segment of the population. It's all of the people together through their elected representatives that are vested by the Constitution with the authority to make these decisions. And that very, very fundamental and important principle of democracy was vindicated by a unanimous Supreme Court in this case. Now we'll see how it all ends up working out. Our case is still ongoing. There are other redistricting cases that you may be aware of all over the country. Wisconsin has a case in the United States Supreme Court right now. And the question in that case is whether a partisan gerrymander violates the 14th Amendment. So in Texas's litigation, most of the issue is about the way that the lines are drawn and how different racial demographics are affected by those lines, and the racial makeup of the lines, and whether, on the basis of race, people have been discriminated against with the line drawing. A partisan gerrymander, the theory there would just be that the lines have been drawn by Republicans to benefit Republicans, or have been drawn by Democrats to benefit Democrats, and that is unconstitutional as a matter of equal protection. That has not historically, as a legal theory, garnered a whole lot of support in the federal courts. Nobody has won one of these cases on that question. But in the Wisconsin case that's in front of the U.S. Supreme Court now, that I assume they'll decide by June, that's the issue. And so we'll know whether that's going to be a viable legal theory going forward. We'll know whether the federal courts are going to redraw the work of state legislatures on that basis. Very, very interestingly, and it's been in the news recently, the Pennsylvania case has come down recently where the Pennsylvania Supreme Court, so not a federal court, the state Supreme Court in Pennsylvania, ruled that a partisan gerrymander existed in the congressional lines drawn by the Pennsylvania legislature for representatives to the U.S. Congress in Pennsylvania. And the court ruled that the Republicans had gerrymandered the map to benefit Republicans, and that not as a matter of the 14th Amendment to the United States Constitution, or as a matter of the Federal Voting Rights Act, but as a matter of the Pennsylvania state constitution. That political gerrymander was unconstitutional and illegal in Pennsylvania, and the court has ordered new maps to be drawn. So, without commenting really on the correctness of that, I have not looked at the Pennsylvania Constitution. I don't have any idea what it says about this topic. It's very, very interesting, right, that the Pennsylvania Supreme Court chose that route, a route that departs from traditional redistricting litigation and look to its state constitution as opposed to the federal constitution. These cases are almost always litigated as federal cases. And this is a point that's often overlooked when we talk about constitutional rights and we talk about federalism, is that state constitutions are not worded exactly the same as the federal constitution. Most state constitutions, including Texas's, contain similar language, creating similar rights: freedom of speech, freedom of religion, rights to life, liberty, and property with due process of law. Rights that sound a lot like the rights we're used to thinking about when we think about constitutional law, when we think about federal constitutional law. But they're worded differently. Sometimes very differently, sometimes just slightly differently, but often in state constitutions, these rights are described differently, using different words. And as textualists and originalists, I think we should be interested. We should be really interested in exactly why our state constitutions are worded differently. Texas's constitution, is worded quite a bit differently with respect to several fundamental rights, including freedom of religion. And often what state courts will do, what a lot of the state court cases say when litigants bring claims under the state constitution, is that we're going to look at, we the state court are going to view the right under the state constitution as the same as the right under the federal constitution. And we're going to take the federal case law and the development of constitutional doctrine that has arisen around the text of the federal constitutional protection. We're going to import that into our analysis of what the state constitution means and essentially merge the two and treat them as if there's just one right, one freedom of speech right in Texas, one freedom of religion right in Texas, as opposed to there being two distinct rights that flow from two distinct constitutions, and that the people benefit from both of those. And then the people of the several states benefit from whatever is in their constitution, as well as what's in the federal constitution. And merging the rights like that, it has the practical benefit, I think, of simplifying the law, of making it a lot easier for people to understand what their rights are, and when lines of legality and constitutionality are crossed. But as I said, and as textualists, one of our touchstones of constitutional or statutory interpretation would be the principle that when different words are chosen, there's a reason for the difference. And when these state constitutions were written, by and large, they were written by people who knew exactly what the Federal Bill of Rights said, and who nevertheless chose different words than the words that we have in the federal constitution. And so why did they do that? What do those different words mean? What's the historical basis for that decision? Do we even have a historical record that could shed light on why those decisions were made by the people who wrote and ratified our state constitutions? I don't know the answer to those questions. I have not studied this deeply, but I've frequently been, it's just had an impression on me looking through our state constitution and the Bill of Rights in the Texas Constitution, and take a look at it. It's not long, and it's really striking how subtly different the state constitution is in many ways from the federal constitution. And certainly we see in the Pennsylvania case that whatever the differences that may exist in Pennsylvania's Constitution were enough to convince the Pennsylvania Supreme Court that what doesn't violate the federal Constitution actually does violate the Pennsylvania Constitution. As I said, it's not something that I've studied a whole lot myself, other than to just note the interesting question, but it's something that I think would make for a great student note or research project, or a great topic to pick up and look at something in the Texas Constitution that the courts treat just like the analogous provision in the federal Constitution, and then go back and look at when the state Constitution was written. In 1876 is when most of it was written, after Reconstruction, and see if there's a historical record indicating, as a matter of originalist interpretation, how we should view what's in our state Constitution and how we should interpret the difference between the state Constitution and the federal Constitution. So if you look into that and come up with a paper or a note or an idea at all, please let me know. I'd be eager to hear your thoughts on it. Listen, as I said, I'm just delighted to be here. I'm very, very fortunate to be in the position I'm in, having just been appointed running for election in 2018, which is a whole other can of worms. But anyway, I just appreciate you having me here, and I would love to answer any questions that anybody has about what we talked about or anything else that's on your mind. Yeah.
So, have you looked at the sports betting case in New Jersey that's in the Supreme Court now that people are hoping will give some bite back to the 10th Amendment? I don't know if you've looked into that, if you would want to
That crossed my radar screen several months ago,
okay.
but I don't remember. Yeah. It's Chris Christie is I think one of the parties.
Yeah,
in
I think
that
so.
case.
Yeah, I just know that they were
Yeah.
trying to pass a law that was forbidden by the federal government.
I was the governor's general counsel. Chris Christie's general counsel reached out to me about that case, and we discussed it a little bit, but I can't really remember the details, to be honest with you. Sports betting, though, is an interesting topic.
Yeah.
Do you know what the case is about?
Yeah, they're wanting to bet at the racetrack or something. I don't know.
Okay.
Yeah, I just know that the big the bite to it is that Congress passed a law saying no state that has that doesn't allow sports betting past this date can pass a law that legalizes sports betting. And New Jersey's well, we want to legalize sports betting, and so they did, and now they're getting some grief from the federal government, so they're challenging it. Anyway.
Yeah.
Having served as the governor's general counsel, do you mind talking about the transition from being policy-oriented and finding how the law can benefit an agenda versus switching over to thinking about the law and not completely switching?
That's a great question. And on a personal level, for the people on the bench, that is the kind of question that we have to be cognizant of all the time. You do transition. When you go from being a lawyer to being a judge, you transition from being an advocate with an agenda for your client to being a neutral arbiter. And not just any neutral arbiter. Your neutrality as a judge is absolutely essential and fundamental to the entire system. And so for myself, the way that I have gone about trying to navigate that is just to constantly remind myself of where I am and of how much bigger this role on the Supreme Court is than just me. It's not about you when you put that robe on. That's the whole point of those robes, historically, is to promote the conception that the judge is sort of behind a veil, and this is not about who that judge is, it's about what the law is. And the identity, the individuality of the judge is not supposed to matter. We're ruled by laws, not by people, not by judges. And so as a judge, it's incumbent upon us to not just to have that in our heads and to understand intellectually that that's our role, but to remind ourselves of that constantly and to check ourselves. As you're looking at a case, as you're thinking through something, you have to constantly be thinking about, all right, is are my own biases, my own background, the other cases that I've worked on, the issues that I've advocated for, is that what's influencing the way that I'm reading this brief or looking at this issue? Do I need to step back and make sure that I'm looking at it through a completely neutral lens? And the only way to do that well, I think, is to be always vigilant, because we're all human beings. We all come from different backgrounds and have different perspectives. And if you won't admit to yourself as a judge that you are a human being with your own personal background and experience that can influence the way you look at cases, then you'll be oblivious to the ways in which your own background might improperly influence you. So that's what I try to remind myself of as much as I can. And I don't think that's just a symptom of being a new judge. I think that's what we all have to constantly think about. Yeah.
So you talked about this one way we should think about the difference between federal and state law. What are some other ways that we should, as law students who spend a lot of time studying federal law, federal rules, and civil procedure and evidence, but are going to spend most of our life practicing state law, what are some other things we should think about while we go through 3 years of law school?
You know, my history of practice was probably 70 or 80% federal law as a litigator. I worked on securities litigation at the law firm, which is almost all in federal court. Then I was working on these constitutional cases in federal court for the Attorney General. And so I transitioned now to the state Supreme Court, where the panoply of issues that you look at is really much different. I mean, we are doing primarily at the Supreme Court and in state courts generally, we're doing common law. These are tort cases, contract cases, property cases, oil and gas cases. So your 1L classes, your introductory classes, where you learn, hopefully, the history of the way those ideas developed and the basic principles that exist, not just in Texas common law, but in most Anglo-American common law jurisdictions. Those classes and those core principles of contract law, tort law, property law, that's what you're going to come back to. As a general practitioner of litigation in the state, or even as a transactional lawyer, thinking about the way courts are going to interpret the contracts that you're writing. Those 1L classes that form the basis of your knowledge about what it is to be a lawyer, that's really what you're going to draw on. And if there's a way to take advanced common law contracts or advanced common law property, that's going to be a huge benefit to you if you think that your practice will be primarily with state law. Because so much of federal law is about text, it's about statutory text and constitutional text, whether it's the bankruptcy code or it's federal regulations or the rules of civil procedure or the Constitution. So much of state law is common law. It's developed over time by courts. And you end up, I'm right back where I started. I'm on the Texas Supreme Court and I'm thinking through the exact same issues that I thought through as a first semester 1L, trying to sort out cases from the 1700s about what's a contract and what isn't. There's a reason that you learn that stuff. Yeah?
I was just curious, you mentioned running for re-election. What is your opinion on judges in Texas, and specifically judges on the Texas Supreme Court and being elected?
Yeah, it's a good question. There are, I think, arguments to be made on either side of that for sure. As a practical matter, experiencing it myself, I think the best argument against it is just that it takes time away from the important work of trying to figure out these cases. But what it also does is that it injects a measure of accountability into the system. Any system of choosing judges is a balance between the independence that's absolutely essential to the neutrality of a judge and accountability. And even at the federal level, there is accountability, and you see it in the confirmation process. You see it in the fact that the judges are chosen by a politically elected president. I mean, there is some measure of, there is a tethering to the people and to politics that exists even with a life-tenured judiciary. Now, certainly the people who wrote the Texas Constitution, when they were balancing accountability and independence, they valued accountability. And when you look at the decisions that judges make, particularly on Supreme Courts, that have enormous impacts on society and end up resolving many contentious political issues sometimes. Redistricting that we just discussed can be often resolved by courts. The fact that courts, particularly Supreme Courts, can and often do make decisions like that is certainly a reason to support some greater measure of political accountability. Ultimately, that's what our Constitution says. That's the system that we have, and I'm privileged to be a candidate. I mean, it's fun to go around and talk to people about what we do as judges and the importance of the rule of law, the importance of respecting the limits on a judge's role. Those are big issues that people, even people who you might not imagine engaging with those issues, understand the importance of those issues and want to hear from judicial candidates about what the courts need to be doing, what the courts don't need to be doing, why it's so important that we maintain the rule of law in our state. And so it's an opportunity as a candidate to talk about those issues and help people understand why the legal system is so vital to our liberty and to everything that goes on in our state. So if we didn't have the ability to do that, I mean, federal judges aren't around, spreading that message. If we didn't have the elections, we probably wouldn't be doing it either. So that's another benefit of it. Anybody else? Yeah.
I know some of your colleagues have expressed a desire for nonpartisan elections. Do you think that would be a better balancing of independence and accountability?
I don't know. These elections tend to be very low information affairs. For better or worse, most voters are not all that knowledgeable about who those people are on the ballot, particularly when they get near the bottom of the ballot, where the judges are. I mean, you guys are in law school. I'm a judge, I've been in government for many years. We all have to admit, we've gone into the ballot box and not known for sure who those people are in that last race. And maybe you just pick a name, maybe you leave it blank. But that's what you have a lot of the time in judicial races. And so at least the R or the D next to the name, when most people voting don't know who those people are, the party affiliation does tell you something about that person. And so it does have that benefit of providing a little bit of information to the voters about where that person comes from and how they are likely or unlikely to behave as a judge.
You see a way to get more information out to voters. I was filling out my absentee ballot the other day. There's very little available, and I'm educated, and I could potentially go pull cases and read judges' signs. Like, it's impossible for the populace to know anything about these judges other than the campaign statements that they put on the website.
You're not going to get on Westlaw and read the incumbents' decisions?
It took me a long time to fill out what little research I did. Do you see any solutions to that? Getting information people can actually digest to know what judges are like?
It's difficult. There's not an easy answer to that. I mean, people's engagement with that sort of thing depends primarily on their interest level. I do think, as I said, that there may be an increasing interest in judicial races and in what courts are supposed to be doing because the influence that judges have had, particularly at the federal level, over the outcome of so many contentious political issues lately, is something that people notice. Regular folks know that that's what's happening. They know that often judges are deciding issues that should probably be decided by the people and their elected representatives. And so there's an interest, there's a sense that we need to know what we're doing when we're choosing these judges. And that these decisions about who these judges are can have enormous ramifications. People know that. But there's just so many races on the ballot, so many judicial seats to think about. It's difficult to expect people to engage deeply in it. But look, it's the system that we have. And at the end of the day, whether people know a lot about everyone on the ballot who they're voting for or not, the people are sovereign. We, the people, created the Constitution. And if they make a decision, whether it's informed or not, it is their decision, and they're ultimately in charge, and that gives a measure of legitimacy and tethers what the elected official is doing to the people and to democracy in a way that is very, very valuable to the system and to people's confidence in the system. Even if it does result from a sort of an uninformed choice at the outset, it nevertheless leads to a situation in which nobody can complain because everyone had the chance to vote. And the person who is now in power did get the most votes, and so the people have spoken. And if the more that we pull back from that, and the more that our instinct is to withdraw from the people their sovereignty because we deem them to be insufficiently informed or capable of making the decisions, the more we go down a very dangerous road that leads to illegitimacy in the government. And there's no perfect system, but even an uninformed and sort of haphazard democracy, which is perhaps what most democracies are, is a whole lot better than rule by those who believe their judgments are better than the people's.
Even though everyone on the Supreme Court right now would have an R next to their name, Texas Supreme Court,
Yeah.
I've heard that there's still ideological differences between the justices. In your time on the court, have you actually seen that? Has it been something where, as much as you can speak outside the conference?
Sure.
Yeah, justices still do disagree with us, even though they are each other, even though they're in similar parties.
Yeah, the judges on the court disagree all the time. All the time. As I said, most of the cases that we get are common law cases. These are tort cases, contract cases, property cases. We get statutory interpretation cases. We get family law cases. And the reason these cases get to the Supreme Court, by and large, is because they're difficult, because they're interesting, because both sides have intelligent lawyers telling them that you can win in the Supreme Court. No one's given up. No one's accepted what the Court of Appeals has said. No one's listened to their lawyer who says you're going to lose. Both sides think they have good arguments. And so frequently we get cases that are close and interesting and difficult. And the judges do, just in the limited time that I've been there, I've seen vigorous debate and discussion about a lot of cases. And it's done respectfully and collegially, but it's done with a seriousness and a real desire to get to the bottom of these cases and decide them correctly. And I don't know if I'd describe it as ideological gaps between the judges. I think you would get lost pretty quickly if you tried to pigeonhole the justices on the court as being in different ideological camps. But there are very, very frequently serious disagreements about how to decide the cases. It's a very intellectually curious and active court.
But along your line, it doesn't seem like there are as many dissent opinions or closely split opinions as we've seen in federal Supreme Court. So what's your opinion on that?
I'd have to look at those numbers in terms of how many dissents there are. It feels like there are quite a few. Just going through the cases we're working on this spring, but I don't know honestly how it compares to the federal system.
So in constitutional law right now, I apologize for the ask, I had to come in late. well, we kind of read through cases and, you determine if this is a functionalist interpretation or a textualist reasoning and those types of things. And I guess, do you subscribe to a certain judicial philosophy that you look through that lens consistently? Or and if someone asks, I apologize for bringing it back up, but I just didn't know how important that is to you to have a consistent lens to look through if you kind of approach each case.
Yeah. Judicial philosophy is, having a coherent and consistent judicial philosophy is essential for any judge. I'm certainly a textualist when it comes to the Constitution. The reason for that is what I mentioned just a few minutes ago. The people are sovereign in our system. And the people of the United States, and with respect to the Texas Constitution, the people of Texas gave up a little piece of their sovereignty when they entered into the Constitution. They agreed to be governed by certain rules and to have their authority limited by certain guaranteed constitutional rights. When they did that, they didn't agree in the abstract to the freedom of speech, or the freedom of this, or the freedom of that, or to principles of due process. They agreed to words on a page in a legal document. That's what was ratified. That's what people agreed to be governed by. There's a legal document that enjoys the consent of the governed. And the words are right there on the page. And so the only way, I think, to do what judges do legitimately is to look to those words on the page and try to do your best to figure out what they mean, what they meant to the people who wrote them, and then effectuate the will of the people by only enforcing those rights and that understanding of the Constitution to which the people have consented. You go beyond that, you get into a realm where you may be starting with the text, but what you're really doing is imposing your vision of what the Constitution ought to be protecting, or an evolving sense of what these words now mean to us, even though we know they didn't mean anything like that when people consented to be governed by them. If you do that, the linkage between what you're doing and the sovereign people is severed. And people may just sort of assent to go along with you and not raise too much of a fuss about it. But if you approach the Constitution as a living document, you're imposing ultimately your view of what it ought to mean, instead of the people's understanding of what it meant when they agreed to be governed by it. And that to me is just a fundamental breakdown in the way our constitutional order is supposed to work. So that's why I'm a textualist.
I'll take one more question, maybe.
Yeah.
I guess could you speak very briefly to your opinion on like the Lochner doctrine coming back into Texas Supreme Court through Patel, and I guess what you think about that?
Well, you should ask my predecessor about Patel. I don't know nearly as much about that case as I know that he does. And my understanding of that case, and so much has been written and said about it, and it's a fascinating topic. My understanding of that case is that what's actually going on there, for the most part, is that the court is applying rational basis review under the Equal Protection Clause to a statutory regime that, in the court's view, after looking at the record and looking at the situation, in the court's view, there was no rational basis for what the state had done. That's how I, based on my limited understanding of the case, how I understand it to have been decided. And that is actually pretty squarely within conventional methods of applying the 14th Amendment. I don't know that that really resurrects economic substantive due process along the lines of something like Lochner in the way that people have sort of imagined that it may. I'm not sure that that case actually does that, but I would imagine, in fact I'm sure that before too long we'll see, I hope we see good briefing and good arguments in our court about what that case means, and I'm sure we'll have the opportunity to study it and apply it further in future cases.
It's 1 o'clock, so
Yeah.
Join me in thanking Justice